is Grace Rains, and today we're going to talk a little bit about venture law. I'm joined today by Reese Dollins with Venture Law Partners, and we're going to talk a little bit about venture law. Do you want to tell us a little bit about you to start us off?
Yeah, thank you so much for the introduction. I'm one of the founding partners of Venture Law Partners. We are a corporate and private wealth law firm located in Northwest Arkansas. My background in particular is in commercial finance, M&A, venture capital, and private equity transactions. And so we had the fortunate pleasure of working with a lot of great clients and individuals through various investments, and we've had the opportunity to see a lot of successful companies, a lot of successful exits, and some not so successful along the way. So hopefully we can shed a light on the do's and don'ts.
Yeah, well, we'll just focus on the successful ones
That's right.
today.
Yeah.
So we've got a lot to uncover. There's a lot I want to talk about. Law is an important topic, and it gets really complicated, especially when we start talking about venture law. And so I want to dive straight in, and I want to start with just the basics, a softball question. So what is the difference between non-accredited and accredited investors?
Yeah, it's a great question. We see it all the time. And it has deep implications in the legal world, but essentially most offerings or raises that investors look to participate in are going to be structured and geared towards accredited investors. And essentially what the SEC has done in layman's terms is set a threshold for what, from a monetary standpoint or just a general wealth standpoint, of what investors are willing to bear from a risk and economic burden. Mm-hmm. Meaning that if they were to lose the entirety of their investment in a given company, their day-to-day life would not change. And so it's kind of a moving target, and if you ask a lot of folks, you might get some different answers on if it should change or not. Mm-hmm. But it's largely based on, what your asset value looks like or how much money you make in a given year, and you can combine that with your spouse at any given time to kind of combine, what your total income looks like. And so within the realm of accredited investors in particular, I believe that the annual threshold right now from an income standpoint is currently at $200,000, or a base asset value of at least $1 million. And so when we start talking about making offerings or being able to participate in investments, that's the bar. And so if you don't meet that bar, then you can be excluded from potential opportunities from the investor standpoint. And so I think a lot of what we're going to talk about today is how we can kind of navigate some of those waters, hopefully, and make sure that we're not completely excluded in the event that we don't fall in the accredited investor bucket.
Yeah, so I want to talk a little about the difference from a legal perspective between venture capital, angel investing, and crowdfunding, and if there's really any differences there when it comes to like the legal ability to invest in those rounds.
Yeah, so all of those regulations that you just mentioned are what we refer to as exemptions or safe harbors from registration of the sale of securities within the lens of the SEC. And so primarily speaking, in the world of accredited investors, we focus on Reg D exemptions, which is we call 506B, 506C. 506B, you can have an unlimited number of accredited investors. You can also have up to 35 unaccredited investors. For a 506C, you can only have accredited, and the reason is because we can now advertise the offering to the general masses. And so since we're advertising, we're saying that you have to be accredited because we don't want there to be misinformation or misadvertisement to trick potential unaccredited investors. In the world of Regulation A and crowdfunding, now we open up the door and opportunity for unaccredited investors to get in the game. Regulation A is largely referred to as kind of a mini IPO. And this allows unaccredited investors to participate within certain raised limits. You can only raise up to about $25 million for a Tier 1 Reg A offering, or up to $75 million for a Tier 2 Reg A offering. But the compliance side, from a company formalities and disclosure standpoint, is really burdensome.
Yeah.
But it allows the unaccredited investors to participate, so we can have an unlimited number of them to step in. Very similar in the world of crowdfunding, and we've seen it now where a lot of portals and companies have opened up these platforms to allow folks to essentially be able to invest in companies at the click of a button. Yeah. But there are some strings attached to it. There's some really good in the sense that the opportunities are now out there for anybody. Yeah. I think investors sometimes fail to recognize the compliance mechanisms that go in behind it, and why they have to jump through the hoops they have to. And it's because these securities exemptions are for their benefit. We want to make sure that they're receiving the information they need to appropriately evaluate the risk and also the opportunity at large to make their decisions informed.
Yeah, no, that makes a lot of sense. And so as you're navigating different types of raises and what it looks like, who really bears the legal burden or the risk of ensuring that the right people are investing in a deal, or, you know, accredited versus non-accredited, and how all that looks?
Yeah, so largely, as I kind of alluded to, securities laws are in place for the protection and the benefit of investors, to make sure that we're not being defrauded by companies. And so by virtue of that, companies and founders are going to bear the greatest burden of making sure that they comply with securities laws. That being said, we also want to be prudent investors. And by virtue of that, we don't want to assist companies in having fraudulent offerings or not complying with securities regs on their side, because it can have implications in a financial sense, not only to the company, but potentially to the investor generally, to the extent that we knew about something that was incorrect. We helped the company do it and raise money despite that fact. Essentially, the penalties are we could lose our investment, and we could be assessed fines to the SEC to the extent that we were actually knowingly and kind of participated in that conduct.
So I want to switch gears a little bit and talk about investment structures now, and kind of legally how investment structures work. Let's talk about, you know, the different, you know, priced equity versus a convertible debt versus, you know, a convertible equity, and what the differences are from a legal perspective.
Yeah, so you hit the nail on the head. There's essentially kind of three main buckets from an investment standpoint. There's priced equity, which, you know, it sounds about how it is. We're offering 100 shares of stock at X value per share.
Just like Shark Tank.
Just like Shark Tank. We're putting on our Mark Cuban hat, and we're investing in the company. And once you participate in that, you own the stock outright. You're now a shareholder. You have the rights that are afforded to you, whether it be, you know, statutorily speaking, or through the governing documents that is the company. So your bylaws, stockholders agreements, and everything else. The other two options, which are, you know, more common in the angel investment and venture capital space, is that through SAFE agreements and investment through convertible debt. SAFE agreements, which, you know, the acronym is kind of says it all for us, is a simple agreement for future equity. This is what we call a very company-friendly investment document. And the reason why we kind of refer to it that way is because, let's say I give you $100,000 to a company in the form of a SAFE. Well, the company receives the cash outright. They can go invest it, they can go put it to working capital, but I don't own any stock. My stock will only come to me in the event of what we call a qualified financing or a sunset provision in the SAFE. And so a qualified financing essentially is where the company goes and does a subsequent offering or a priced round of the sale of equities to other investors, and it has to meet a certain threshold. And so let's say, for the sake of argument, that the company never does that. Well, guess what? We don't own any equity. And so that's one of the downsides of a SAFE, is like, well, where does that leave us? So we don't have any voting rights. We have very limited protections. We just know that we gave the company money. We hope that one day it converts. We don't really have any control on as to whether it does or doesn't. And so we'll just enjoy the ride, I suppose. On the flip side of the coin is the convertible debt piece. This is what we tend to refer to as more of an investor-friendly document. And the reason being is that the convertible debt, the investment, in that same scenario, I give a company $100,000. Well, now it's going to be treated as debt and accruing interest, let's just say at 8%, meaning that if the company, under the same circumstances, never goes out and raises a dime, I now at least have the option on my side of the fence to force convert my capital into equity of the company, or treat it as debt, meaning they now owe me that money back, just as though we were the bank. And so by virtue of that, it's a stronger position for the investor to be in, and they have much more of a say in what their future holds from the investment position. And so anytime I represent investors, I always say if we can get convertible debt, if there's a convertible debt offering, let's take a peek at it, because it can be really advantageous, because the interest that's accrued, depending on how it's structured, that can roll into more stock. And so let's say, we get $8,000 to $10,000 worth of accrued interest. Well, that's more shares that we bought on the same value of the investment that you would never get in a safe. And so there's kind of intangible benefits there that really compound over the course of time.
Yeah, absolutely. So compounding on that, when we start talking about terms and the term sheets of some of these deals, what types of terms should investors be looking at and be concerned about from a legal perspective?
Yeah, I think we could probably talk about this for a long time.
Yeah.
We'll try to keep it short and sweet. There's always a few high-level points that we always want to see from the investor side, because by virtue of making a really early-stage investment, we don't know what the future is going to hold.
Yeah.
But we want to make sure that our ability to stay in the game, to stay involved with the company at a meaningful level is preserved. And so some of the things that we always look for are pro rata or preemptive rights, which essentially what that means is that if something's going to be offered to some of the investors, I get the ability, at the very least, to participate in my capacity with respect to my equity as well.
Yeah.
So we want to make sure that we have that in there. I always like to include what we call a most favored nations, or an MFN clause. And essentially what that means is that you can't go offer me this deal and then go offer my neighbor or another investor a better deal just because you wanted his capital more. You have to treat me like you treat your best investor. Okay. So we're all on the same footing. And so that's always a term that we like to include. It shouldn't be met with resistance, because the feedback is, well, what are you trying to hide from me? What are you trying to do? But kind of piggybacking off that, we also like to make sure that we're protecting the integrity of the investment, and that largely gets into having anti-dilution protections in the term sheets or in the investment documents, and essentially what that is let's say we make that $100,000 investment, and the company was raising that on a valuation of $1 million, so that's 10% of the company. Well, let's say 2 years from now, they're raising more money, except this time it's at a $500,000 valuation. So we've gone down from a value standpoint. Well, what happens with my equity? Do I get crushed down, or what happens? If we don't have any dilution protection, we get diluted down, and there's nothing we can do about it. To the extent that we have certain anti-dilution protections in there, we can actually recalculate our equity based on when it was invested a couple of years before, to make sure that maybe it doesn't disproportionately impact us, or maybe we get slightly more favorable treatment. It still won't be a positive, but we're protected more so than the guys beside us. And those are all wins in the world of investment, because the name of the game is making sure that you keep your percentage equity and the value of your equity relative to the dollars that you invested.
Yeah.
And so any dilution protections are big. We always like to include those. Most favored nations is obviously a big part of that, and I'm sure there's a few that we could talk about it here ad nauseum, but those are kind of the big 3 or 4 that I always check the box on the investor side.
So what about liquidation preferences? Where do those kind of fall, and what should we be concerned about? Yeah,
I knew I was missing. I knew I was missing one. Depending on where we're investing or what stage of the company we're investing in, it's always nice to try to include some type of liquidation preference. And so essentially what that means is that when the company gets paid or we have an exit, I at least get my dollars back first before anybody else participates, because while founders may have sweat equity in, I put real capital in. And so we have to make sure that's paid back. And so that's a protection for the investor. And there's a few different types of liquidation preferences. There's full participating preferred stock, and there's just participating stock. And full participating preferred means, let's say I give you my $100,000. You're going to make sure you pay me 1x or 1.25x my money back first, and then I also get to share pro rata on my percentage ownership with the sale of the business. So we get to double dip, which is a really big win for the investor. So if we get that, that's fantastic. We would love to have it. Not very common. That comes up usually in distressed financing transactions. But the other one is that I essentially get to pick. Do I get 1.25x or 1x my money back, or do I get the percentage I would receive if I just participated like everybody else based on my ownership value? And so I get to pick the value that gives me the most cash or the most upside back in my pocket. And having that flexibility at the investor level is a huge upside.
Awesome. So what about like board seats, voting rights? How does all of that play in to negotiations around term sheets? In what kind of deals can that be expected, and what kind of deals, is that not really an option?
Yeah, so board seats, advisory positions, those are always negotiating points. We kind of refer to those as business points less than legal, but they're really important to understand nonetheless. And it largely comes down to how much money you're putting in the deal. Because if you're a lead investor in a transaction, odds are you're probably going to have the ability to request either appointing your own board member or having a board advisory position. That way you at least get to be in the room, listen to the conversations as they're had. As we've all probably know, either from experience or at least watching TV shows, the board in a corporate sense is kind of the heartbeat of the organization. You control the board, you control what the company does. And so having the authority to appoint a board member can be really impactful to make sure that you have the inside to what the company is doing, not only from a revenue standpoint, but just from a general, hiring, firing, expansion, what that looks like, And so to the extent that you're making a really meaningful investment, especially relative to the size that of what the company is trying to bring in, I think it's more than appropriate to ask either for at least visibility from like a shadow board seat or an advisory position, or truly to either for you to sit on the board or to appoint someone to the board, because that's your greatest strength is, you can be in there and be the sounding board. And sometimes companies want that. They want your expertise. They want a fresh perspective. And so, they may not all go for it, but it's worth asking for.
Oh, absolutely. So what do you see as the advantages of working with your own legal counsel when negotiating these types of terms versus just working with the legal counsel of the startup company or representing yourself, or how does that look? Yeah,
I wish more people asked that question. I wish more people cared enough to ask that question. The real big difference is that company counsel represents the company. They don't care about the investor. If we get your money, great. If not, my recommendation is let's go find somebody else. And so you truly, if you're relying on company counsel, you don't have anybody advising you as to what is normal, what is standard. No one's helping you with your own diligence process and looking into, is this a good investment? They want you to sign on the dotted line to get the money in so they can close out their investment. And so by virtue of that, you may as well be unrepresented. You may as well be you versus the other, the company's attorney and the company at large. And if you ask me, you're outnumbered. There's a reason why we have people hired to do our taxes and insurance and everything else, is because they're the subject matter experts in that. And so you want somebody in your corner that has a deep understanding of this, that can really kind of put the checks and balances in place to what the company is seeking from an investment standpoint, and also making sure that you're protected, and making sure also that they're being compliant with securities laws, helping you with due diligence and things of that nature. Certainly it is a cost component of making investments, but the upside to it, I think gives you peace of mind knowing that the integrity of your investment is in good shape.
Yeah. All right, so you touched a little bit on due diligence earlier and talking through the advantages of that. So what basic legal due diligence should investors always check before they write their check?
Yeah, I think if you ask 10 different people, you might get 10 different answers for that. But generally speaking, there's a lot of overlap. And from my perspective, it's really important that we get, depending on what the company is that we're looking to invest in, just at a non-starter position, what are the financials? Do we have audited financials, or are they yearly? Give me the quarterly cash flow statements. All the financials I need to take a look at. Let's see, is your revenue projections matching with what you're telling me? What does your customer list look like? Are we growing? Are we stagnant? These kind of help you make your own models and your own projections internally. But one of the biggest and kind of most slept on pieces of diligence, quite frankly, is in the world of IP. Particularly in the world of AI, if we're investing in an AI or tech-based or cybersecurity-based company, do we have strong intellectual property rights? Do we own what we say that we own? And is it protected either by patent or trademark registration or through licensing agreements? And if we purport, or if the company purports to say that we do own it, well, go ahead and show it to us. Because if the value of the business is largely held in the IP and we don't look at those documents to verify, well, then that's kind of an unsecured investment. And so I would say that our diligence needs to be focused not only from a financial lens, but also in an IP lens to make sure that you're getting the full picture. And by virtue of that, you're going to have a lot of conversations with the CEO and probably some board members where you get to learn more about, what does our hiring and firing processes look like? What do our strategic advisors look like? And so I think those are important conversations to have to get to build out what you're looking for. But my two non-starters are in the world of financial diligence and actual IP diligence. Now, from that, you can get really nuanced and granular as far as what you request, or you can keep it high level. But I think you at least have to kick the tires in both those buckets to say, hey, I'm doing my part, I'm looking at the things I need to be looking at. And it's funny, that's why you also want your own attorney, because it doesn't do you much good if you say, well, I requested it, now what?
Yeah.
What do I do with this now that I've got it? And so you want somebody in your corner, whether it be the CPA that you trust or your attorney that says, these are the diligence documents they've given us, these are the contracts, the customer contracts, how are we looking? Because it's great if the company did $5 million worth of revenue last year, but if all their contracts are set to expire in 6 months, well, what are we actually investing in? Do we own the assets that we say that we own? Or are they leased? What does our debt on the books look like? And so those are largely, I kind of pivot into the financial bucket of things.
Yeah.
And so you can kind of take a shotgun approach at it, but if you at least focus on those two segments, you'll kind of figure it out and keep it between the ditches from there.
Yeah. So along that line of contracts, client contracts and other contracts, founder agreements, things like that, what types of red flags are we looking for in those documents as part of the diligence process? Yeah,
things that we look for internally with respect to founders is how have they treated their own stock to date, to the extent that it's visible. And what I mean by that is, have they made appropriate tax elections to the extent that they've granted themselves restricted stock? Do we have good governing documents? Do we have true stockholders agreements, bylaws, voting rights agreements, things that if we were writing a big check, we would expect to see on our side to make sure that we're protected? Or is it largely unorganized and the company's saying, hey, trust us, we have a really cool idea, let's take it to the moon? Well, that only does so much for us. And so we want to make sure that they have the paper trail and that we can track, even from the outside looking in, what has happened to date. We want to make sure that the founders, to the extent that they're employees of the company, have their executive employment agreements. What does that look like? What do these terms look like? And then not only that, you allude to on the customer side, what is our ability to get in and out of customer contracts? Are we going to be penalized if we need to terminate and go with another vendor or another supplier? If so, is it going to be punitive? Is it going to cost the company 6 months to recover from that? Or can we terminate at will? Can they terminate at will? Is that going to completely upend our industry? One of the things that I've seen before, a client came to us and they were really excited. They signed up 6 really large clients, and they said, we locked them in for 2 years. And I said, well, you think you locked them in, but they can terminate anytime they want with 15 days notice. And so that revenue, even though it's monthly and recurring, if they ever change their mind, is gone.
Yeah.
And so from the investor side, you want to know that. It's like, what's the stability here, and what are our contractual rights to the extent that we need to protect those once we're a shareholder?
Yeah. And how do we define locked in?
And how do we define locked in?
Yeah.
Yeah, that's right. And so what are, it's because now once you're a shareholder, you kind of are the company. And so you need to look at it from that lens too, is like, how do I protect the company? And so you want to make sure that we have those documents and that we're not operating on handshake deals. Sometimes it works and you get away with it, and sometimes it'll come back and bite you.
Yeah, absolutely. So I want to transition now to to talking a little bit more on the tax side of things. So how is a startup investment typically taxed or normally taxed at exit or following an exit?
Yeah, so that largely is going to depend on the type of exit that we have.
Okay.
And what I mean by that is the two fundamental exit strategies are that of an asset sale and that of an equity sale or stock sale. That of an asset sale, depending on what kind of entity we invested in, whether it be through an LLC or C Corp, is also going to have separate tax implications. So let's say, for the sake of argument, we invested through a C Corp. When we bought, stock in the company, we're selling the business. Well, that C Corp is going to have what we call double taxation. They're going to be taxed at the entity level, and they're going to be taxed at the shareholder level when they pay out your distributions or your dividends. So that's going to be 1099 income that flows back to you. And so from that standpoint, it's really kind of disadvantageous from a shareholder standpoint if we do an asset sale through a C Corp, because that means we have to pay taxes twice. And so the amount of money that you're actually going to realize, net of taxes, net of costs, is probably going to be a little less than you actually contemplated. But one of the primary benefits of a C Corp, and this is why everyone likes to structure them this way, is if we have the right holding requirements and we qualify for it, we can classify our stock as what we call qualified small business stock or 1202 stock. And essentially what that allows us to do in the event that we do an equity sale is we can defer or eliminate, I should say, the greater of 10x our cost basis in the stock, or up to $10 million in gain. And so from a tax strategy standpoint, that's massive. So imagine we invested $100,000 and the company sells for $50 million and you stand to make $7 million. Well, we can practically eliminate all of that gain. And so that can be really big. There are some kind of caveats to that we have to make sure we check the box and do things the right way. But that's why people like investing in C Corps, just so we can get that tax status. Now, if we invest in LLC, it's going to be a little bit different of a structure. Essentially, equity and asset sales at the LLC level are going to be taxed the same. Whether you sell your equity, it's going to be taxed as an asset sale. Whether you sell the assets, it's going to be taxed as an asset sale. And what I mean by that is, to the extent that the company has depreciated assets to date, one, we have to recapture that depreciation and pay taxes on that. And then two, it's going to be taxed either ordinary income rates or capital gain rates, depending on if it's allocated to goodwill, hard tangible assets, or whatever the case is. So it'll kind of be a blended approach on that side. Versus the C Corp side, we largely shoot for just long-term capital gain rates, which we know and we can kind of plan for and say, hey, we're going to be locked in at, 15, 20%, whatever it is for that year. And I'll make my big disclaimer here. Talk to your CPA about that.
I want to talk a little bit about estate planning. It's not the most fun topic to talk about, but as angel investors take on these investments and kind of have that as part of their portfolio, how can they prepare from an estate planning perspective to pass those on to heirs later if it's pre-exit? How do they position themselves well?
Yeah, there's probably a couple different ways you can do it. One, you can invest directly through your preferred estate planning vehicle. So oftentimes that's going to be revocable trust, or maybe irrevocable trust for the benefit of grandchildren or children. So we can make the investments directly through that. So we've incorporated our investment strategy with our estate planning strategy, and it's a kind of a beautiful thing. It's really easy, and it's taken care of right then and there. To the extent that maybe we didn't have that foresight, or we need to make changes and we've invested in our individual name, there's other strategies to where you can essentially do assignment on death, or death designations and beneficiary designations on your stock. Depending on which state you're investing in, they'll have certain restrictions from the estate planning side as to what will qualify for that and what won't qualify for that. But one of the biggest gotchas that we need to flag is we need to make sure that the governing documents of the company we've invested in allows for what we call intra-family transfers or estate planning transfers, meaning that if I want to transfer the equity from my individual name to my trust, that doesn't trigger the right for somebody else to now buy me out of the business.
Okay.
And so those right of first refusals that are kind of commonly found in some of these governing documents, we need to make sure that we're being compliant with that. Now, estate planning transfers should be a standard carve-out. We've seen it to where it's not, and it can really trip some people up. To where if you have a really successful business and you just try to transfer something to your trust, now someone has the opportunity to buy you out. And so we don't want to accidentally step on a landmine just because we're trying to plan and take care of our children and our family. You know.